something from a law firm or a lawyer, we handle those. So, for instance, Kim McKee is in Central HR, and she handles a lot of the requests that come to Central HR for, files, personnel files, investigative files, things like that. But when it comes from a lawyer, she always involves us, because obviously there's going to be some sensitivity to that, because it may signal that there's a pending lawsuit, or someone is involving a lawyer in some sort of investigation that's going on that they're a part of. So we want to know about those, especially because legal wants to know about those, that it's potential risk that there may be some lawsuit involved. So those, and sometimes even just the more complicated, where they're not just asking for a personnel file, they're asking for a personnel file, and they want records about the salaries of a department. They want records regarding a RIF that took place, that several people had their jobs changed, or were put into retirement a little bit early. So sometimes those multi-requests, they're not just asking for one record, they're asking for a bunch of records. We handle those. So when we say 443, it's not just one. We're talking about some of our requests that we will turn over hundreds of records to somebody in response to 5 different requests that they submitted as one request. So it's a lot. That's why there's 2 full-time people.
I'm not keeping track of time, and I don't want to run over, so we wave at me, or
I think you should have some more time.
Okay, because I've got some other stuff to say. I wanted to talk about email. Do you have an understanding, I think, about the whole concept of record and public record, and every record is a public record unless it's subject to one of those exceptions. Email, I get this question really quite a bit, and we get lots of public records requests for all email between X person and Y person for this particular date, referring to something or other. And they think that that's a valid public records request. I want to ask, because I always ask this, how many people here think that email is a record? Okay. How many people think that email is not a record? How many people think that email might be a record?
It depends.
There you go, you took the class. She was in my class the other night. Why does it depend?
It depends on the content.
It depends on the content. It depends solely on the content, just like that video from the Blackwell. When somebody makes a records request from us and they are asking for all emails pertaining to so-and-so, the way I read that is all correspondence pertaining to so-and-so. I still come from the paper and pencil days, and so when somebody makes a request for correspondence, I always think, how would I file this correspondence in the ordinary course of business? Does this have to do with this overarching topic? Would I drop it into the folder marked budget for current fiscal year? Or would I drop it into a correspondence folder because it's just general correspondence? So I would probably organize it alpha, or I might organize it by date, because our records retention schedule for general correspondence or routine correspondence that wouldn't go anywhere else might be 2 years, and so I need to know what I can throw out and when. So I do the same thing when I'm getting a request for email. Somebody asks me for email. They ask for all of the email between me and Becky. Well, they're not entitled to everything, even if they were records. The public records law, or at least the Supreme Court in Ohio, has interpreted the public records law to mean that a records requester is entitled to see what's going on in a public office and to scrutinize the public office, but the requester is not entitled to see what is essentially a complete duplication of all of our files. It doesn't allow a requester to virtually pitch a tent outside our door, and as someone passes with a piece of paper, say, could I just take a look at that? Now, that's not what this law allows. The law does require, and the General Assembly felt strongly, the The law requires us to handle public records requests just in the routine course of our business. They're part and parcel of what we do as government offices, as odd as that seems here in a university setting. We're just like any other government office for this purpose. So we've got the obligation to take care of that in the ordinary course of our business, but we don't have to stop business. We don't have to interfere with what our true responsibilities are in order to respond to an overwhelming public records request. So all of the email correspondence, I think paper immediately, paper equivalent, between me and Becky. Okay, how about for a period of time? Let's say it's for a month. Well, you know, that may not be as extreme as some requests we've seen. Sometimes we see them literally for a decade. Sometimes we see them for a year or several months. Maybe we see one for a day or two, and that I'm going to treat a little bit differently because I'm going to be able to find something much more easily. But even if somebody said, all of the emails you guys exchanged that were records that documented university business for a month's period, how do I know what that is? What's the record that they're actually identifying there? They haven't told us. We are supposed to be, and I know that we are not, only Becky does this, the whole university, only Rebecca Gibson does this.
I'm sure that's not true.
Files her emails the same way that she would file them were they paper, by taking them and moving them to a folder that deals with a particular topic, a broadish topic, like public records request from the Columbus Dispatch dated so-and-so. So she can find all of her correspondence that deals with that easily. Or, I'm trying to think of a few other examples, but it's usually going to be project-based. It's not going to be everything having to do with public records goes into a folder and somebody can access that.
Well, and if you start from the idea that when you think about record retention, I know it can be a really boring topic. How many of you guys have taken the paper and bites? Okay, so you know a little bit about, if you haven't taken it or if it's been a while, I would recommend it. I think it's a good reminder of how we should be organizing things. But I always start from the idea that most of my email communication, especially with Lauren or someone in legal like Leslie, where I'm like scheduling something or asking a question about a meeting that we have scheduled, it's probably transient. A lot of email is transient. So I'll have some emails where we actually do make a decision, and there's some guidance from Jan on something from legal affairs, or Lauren's telling me we're going to handle records this way. That type of stuff I will file into that. I will drag it into that folder, and we have it's a 3-year retention period on public record requests. So I just file it away in there, but a lot of the emails that I get are not going to be something I'm going to keep, because does it teach anything about how we conduct business by them knowing that I have a meeting scheduled at 1 o'clock that I've accepted, that I'm going to attend it? No.
Can you explain transient?
You probably do a better job at that than I do.
Okay. Well, transient records retention schedule. Remember I said before, administrative value. If you've got something that has very, very limited administrative value, roughly the equivalent of it's in lieu of a telephone call, or it's something you would have put on a phone message slip, call so-and-so. Well, you take that phone number and you make the call, and then you're done. Or you make a note of it in your phone, here's the phone number for so-and-so, so I'll go ahead and give them a call back. That Post-it note equivalent has no administrative value, certainly no historical, fiscal, legal value, and you don't need it once the matter is resolved. So those meeting scheduling notices, once the meeting has passed, what do they tell anybody about government? We don't need them anymore. So something like that you can ball up and throw away if it's a piece of paper. That's transient. You don't have to go to the archives and say, we're getting rid of it.
I just want to mention the text message conversations we've had before and what that really means when you're text messaging back and forth.
Text message conversations Beth brings up because she knows it's a touchy topic. If you are working for somebody who as doing business by text message over the phone, please do what you can to make them stop. Because if you apply that records test, then what's a text message? It's information stored on a fixed medium, because text is just electronic paper, just like email. Information stored on a fixed medium, if it's created, received by, falls under the jurisdiction of Ohio State, and it documents university business, then why would it not be a record? And then we would have to look at content to determine if it's actually going to be exempt, but otherwise, if it's not exempt, it's going to be a public record. This is really, really difficult for us, because anything that is a record has to be kept for the appropriate period of time, unless it's something transient that is just super limited value. We've got to hang on to it. By law, we have to hang on to that until the retention period has expired. So what we suggest to people who cannot break themselves of using text messaging to, they would never hide things from the public, now would they? Well, they're not supposed to be hiding anything from the public. What we tell them is CC your business email or some kind of an email account so that we can somehow get a handle on it. So those of you who are actually doing the organization of their stuff, because we know that they don't do it, that you can somehow get a handle on it and organize it the appropriate way, or at least be able to access it when the time comes. Like I said, nobody but Becky actually does this level of organization. But if we don't do that level of organization, we are going to have the obligation, if the request comes in, and it's a good request for everything having to do with, say it's a text message having to do with a records request, yes, you can satisfy this, or no, this is attorney-client privilege. If it's something that we have to hang on to for 3 years, we're going to have to go back out, or ask somebody to go back out and gather up all of those things that would be responsive that we should have filed. And our failure to do that, public policy aside and public perception aside, and that's going to be a huge thing, because that's what they're going to lead their story with dispatch.
Just to add to that, and then we'll answer a couple questions. It's the same thing we're talking about when we talk about text messaging. We talk about people who are using their personal email accounts to conduct public business. So is that your question?
Personal cell phone.
Personal cell phone, that's, it's sort of the same thing. When I get requests, and it tends to be faculty a lot, they use their personal email accounts a lot to communicate, and unfortunately sometimes when they're using it, they're not just using it to talk to their students, they're using it to, talk to various people about what business we're actually doing that's government business. And when they do that, they're opening themselves up to actually having their personal email as becomes a record.
Right, the hardware does not matter. Hardware does not matter. The program, the software doesn't really matter. So you could be using your personal account, your personal phone. How much time do we have? Because I've got a little story I can share. Let me share it really, really, really fast. Okay, I worked for 5 attorney generals in my 7 years downtown. One of them was Mark Dan. I don't know if anybody remembers Mark Dan. He was the only, just saying the name, bless his heart. He, I think, is the only attorney general who actually has been kicked out of office in the state of Ohio in our history. And he got kicked out of office actually partially because it was public records related. This is a really interesting line of work. You get to know something about everything. In this situation,
Some things you'd rather not know.
yeah, rather not know, maybe some dirty laundry. In this instance, AG Dan was involved in a extracurricular, extra business, outside of business activity with his scheduler. And there were, people found out about this, and so there were public records requests for his emails. And there were public, now does that document public business emails? He felt he was being overly transparent, which she was, by saying, I don't care if it's public business or not, just go ahead and give out everything. So we all got to learn about everything. But one of the requests that we received from the media was for a lot of travel documents for a trip that the AG was going to be taking overseas. And the scheduler had wanted to go along. I think the AG's wife had also maybe wanted to go along, so there was some, back and forth to try and work all of that out. But so people who were interested in this wanted to know what those public records showed, and those absolutely are public records. They're documenting travel for a public official on a public business. So the request was made, and I was tasked with going to the scheduler to ask for copies of those documents. And she said, well, that's really easy. There are no records. Really? That surprises me. And she said, no, there really are no records because I did this out of work time. It was like 11 o'clock at night, so not regular office hours. I was at home, and I was using my own personal laptop, and I used my own email account to make all of those arrangements. So there are no public records. And I said, no, there really are. So now I'm going to have to ask you to go home and get your computer and come back. And we're not going to go looking on your computer. We're not going to go looking on your phone. The only way we could do that is if we had subpoena power, and we all work together. We're not going to subpoena you, and we don't have that power anyway. But what we do have to do is come to you and say, really, really sorry, but we're going to need you to go back and check his or her email account, or have him or her check the text messaging, and pull together these things that we've determined actually are documents, are records, and should be public records. So the best we can to get everything in one spot where you can deal with it, I think the better off we're all going to be.
If you want to take a couple questions, got a couple, like maybe two minutes. A couple questions. I think you have one.
So when we hear about somebody's computer being monitored, or if I'm not mistaken, if I understood you correctly, if they're doing business with their phone, the only way anybody would know about that is if they admitted it. So it would be silly to CC your email account at work.
Well, I mean, chances are, if they're conducting business on their personal cell phone, they're conducting business with other people who also work at the university. So somebody somewhere is going to have a record of that. So it would make more sense to, if there's somebody who deletes their text messages, it would make sense if they need a record, or if they want to keep track of what was discussed, they should send it to their email account.
Right, text messaging doesn't stay around very long. And I should mention also, as far as our own email accounts, ever since the transition to the single email process at the university, IT is no longer journalizing or saving in a big electronic box. I'm very low tech, so that's the way I picture it. They're not journalizing all of our email. There are very few people at the university who are actually having their email kept in that way. So it's going to disappear after, it's probably a year, it's going to disappear. And all you're going to be able to get on your Outlook is this rolling year. It's progressive. So the thing to do is to make sure that on your Outlook accounts, you're going to see a little box for archive, a file for archive. You want to make sure that your archiving function is set up properly, and ITT can certainly help you with that, or Becky can help you with that because she knows how to do it, to make sure that everything is, after that year, things are rolling into that archive folder, because that's the only way we have of capturing those emails. And if they turn out to be records, and they turn out to be records we needed to keep for a longer period of time, there is, again, a reputational problem but for the university, but there is also a legal problem, because if we improperly destroy public records and somebody sues us over that, they can actually get a forfeiture of $1,000 per improperly destroyed record. There did not used to be a cap on that. In the law, there is now. It's $10,000 for each improperly destroyed record. If you have more improperly destroyed records, those don't count. But a max of $10,000 and $10,000 in attorney's fees.
Another question.
So it sounds like if there is a call on records, you're basically going to have to self-report. So it's not really,
You mean if you receive a record request?
no, like let's say, somebody comes from the outside, they want all the records related to my name or whatever.
Which is a bad request.
Yes.
All the records related to your name would be a bad request.
Right. But I mean, whatever, they wanted something that I had that I use like text messaging or something like that. The universities rely on me to self-report, to go and get my own records or keep my own records. In other words,
Yes.
I come from banking and in that world, they would take your cell phone and your home computer. I mean, everything is like surrendered and then they can go through it whatever they want.
They only do that if you're marked down. I mean, truly, if you're a public official, and that's exactly what they did with his when they came in and they said something is rotten here, hand over your everything, your phone, your everything. But that's not how the public records law is going to work. That's all going to have to be done pursuant to a subpoena or some other
Yeah.
legal authority. What we're going to do is we're going to give you a call and we're going to say, first you're going to call us and you're going to say, I got this records request, can you help me? And we're going to tell you that was a bad request and we don't have to fill it, and we'll help you by sending a note back to the requester and explaining why legally it's not a proper request. If it is a proper request, we can help you out with that, and that he is going to work with you to figure out what you have that's responsive, and that may mean you're going to remember, I have that material that I had either in a text file or preferably it was somewhere in an email file. If it was text, maybe you forwarded it so you can find it. She's going to help you to do the Outlook search or to figure out how you would ordinarily store those kinds of responsive records. And then you'll pile them all up, send them over. Becky will go through them, look for any legal exceptions. I'll go through them, give you my take on those things. We're going to run it by OLA if we feel we've got some exceptions that apply. And then we will let you know how we're resolving it. And go ahead and send out the response. We'll make sure that you know what we're up to with your records.
Keep in mind, last thought is all bets are off if it's litigation. So there's no point in not providing us with all of the information, because if it becomes litigation, subpoena power can go much further than this law does. So
And I think what you were mentioning earlier, I thought you were talking maybe about a litigation hold. If you get somebody, and somebody comes to you and says, we're putting a litigation hold on your email, that's going to be a separate function. That's an OLA issue, not for a public records issue. Although sometimes they may dovetail, that's generally going to be something having to do with OLA and a lawsuit. Yeah. Thank you guys. Very, very